What I'd like to do is I'd like to begin with some of the questions that deal with an important part of this, which is rumor control. There are tons of rumors in the community, and some of the questions have reflected some of those. The first question, and I'm not sure who it should be addressed to, deals with, let's look here for a second to get the wording right. If a suspect has cash in hand at the time of being booked into the jail, will he be given his cash back at the time of discharge, or is he given a county check instead?
You know, that's a good question. One of the issues that we've always dealt with is staff having access to cash, just the accountability issue, and others that might be in the general area that are not maybe medical staff, that type of thing. So what we've done is when someone's brought in and they have cash on them, it goes into a locked receptatory box, similar like a ATM machine. The cash is held there. When they are released, they get a credit card type of a no. Well, okay, we're getting to that. Right now, they receive a check, I believe. But one of the things we're working on, and I think we're pretty close to that, is it will spit out a credit card when they're released that they can use, similar to a debit card. So, but when they're brought into custody, we no longer, and we haven't done this for some time, we no longer have cash available to refund to them when they leave because of the accountability issue. We remove that from the jail, but they're now given a check, and in the future we hope to be able to give them a debit type card so that they can utilize it upon release.
So it might be, we had someone who was going to be writing up here on the board. Thank you. There is a problem then, because someone who's discharged at 1 o'clock in the morning and came in with cash now doesn't have cash and has a check that nobody can cash. So he's discharged
Correct.
without resources.
At this time, that's the way the system
One of the
works.
things that we want to perhaps hold for future discussion and follow-up. Thank you. The second, does the county receive additional income from any source if an inmate is discharged after, say, midnight as compared to being discharged before midnight?
No.
Thank you. I think the sense was from this question that if the county is reimbursed for a census and the census is taken at midnight, and you discharge 5 people at 1 o'clock, then they go home the next day's census.
Yeah. There's no.
Thank you. Thank you for clarifying that. Does the nighttime release policy for females differ for that from males?
Well, what we try to do with females especially is ensure that they have some type of a ability to be transported out of the area upon release. Again, the same is afforded to males, but they're not compelled to utilize it. But females, we try to ensure that they are able to leave the facility with a prearranged ride or a taxi or that type of thing. It doesn't mean that everyone necessarily does, because they have the right to refuse. They can refuse that, but we try to make that a condition of release at the time that it happens. But most of the time, I believe, Ed, if I'm not mistaken, females are or do take advantage of that.
Another question was on the night that Mr. Bullock was contacted by the Utica Police. Was an emergency shelter? Was he directed to an emergency shelter? And I think that's getting into another issue we need to look at, which there is a court order block on sharing information regarding specific cases. And so I'm just going to.
In general, the question I can ask that in general. If there is referrals made or to some type of shelter, we provide that information. Our correctional staff, upon release, especially if it's after hours, we offer them, number one, we'll offer you use the phone to arrange for a ride. We'll offer you the ability to sit in our waiting room until daylight. We'll call a taxi for them. We'll give them information as to where shelters are available. But I think we've already been revealed here tonight, many times after midnight, 1 o'clock in the morning, the shelters are not going to receive anybody.
Yes. This is a common question. There are 3 or 4 cards dealing with this one. Sheriff Downey stated that it would be illegal to hold people longer than, quote, necessary, but the ACLU says that a person can be held for 48 hours before releasing them or filing charges. The person who submitted the question would like Sheriff Downey to please explain what law he's referring to that relates to this conflict of apparent interest.
Under disorderly conduct 647F, that is a more of a protective custody type of a statute. Now, what happens is under 849B2 of the Penal Code, they have the ability, an officer has the ability to declare that this subject, that no charges are being sought against this subject. It goes back to the detox issue we already talked about. Someone who's simply in there under the influence, there's no criminal activity to speak of, there's no associated crime or charge that's going with that, then that person is subject to be released upon completion of, or upon the time that they can show that they're able to care for themselves. The same thing would go with someone that's brought in on a lesser offense that they could be OR'd on. There's a good possibility someone could be OR'd, or again, if bail is set and they're able to bail out at that time.
Please, yes.
That 48 hours that was referred to, that's an outside. So that is the maximum amount of time you can hold someone before they're brought before the court. And that's, they're entitled to a probable cause hearing. That is not, you get to hold them for up to 48 hours. At every step in the way, what the law has tried to do is create protection so that as quickly as possible, there is a third party, in this case, the courts, that will look over, scrutinize the decision-making process and make sure that that person is lawfully detained. So I just wanted to make sure that was clear, because really we don't want to have a situation where we're saying, oh, well, you've got 48 hours. How about you just keep people in custody as long as you can? Because if you release them, they may, in fact, commit an offense.
Please, I was going to ask for your comment on this as well. Thank you.
The 48-hour is for a probable cause determination by a magistrate that there was a basis for the arrest. And the authority for that is the County of Riverside versus, I didn't write down the rest of it, but that site is 1991, 500 U.S. 44. It's a U.S. Supreme Court case. Without undue delay, and no more than 2 days at the outside, is when the person must be arraigned once you've determined that there was a probable cause to arrest. An arraignment is before a judge. And that undue delay, as Mr. Gallego states, is outside limit is 2 days, not including Sundays or holidays. They have to be brought before a court and told what they're being detained for and offered the opportunity to have an attorney represent them. So the distinction, I think, is important. When a person is arrested and taken to jail, they get a review within 48 hours, and that includes weekends and holidays. There's a judge on call who does that probable cause review for warrantless arrest. However, the opportunity to have representation and to seek release on their own recognizance if they're detained beyond that original 48 hours is an arraignment, and that's a different limit. And I can give you the sites for that. Sheriff Downey said 849 of the Penal Code. Also, Penal Code Section 825 covers that, and People versus Lee, which is 38 Calap 3rd, 514, which is a California case that might help with that.
The 647, they aren't arrested at this point. So without an arrest of a person who's under the influence, the 48-hour rule doesn't come into play.
Well, let me read this section to you. 849B2 basically says any peace officer may release from custody instead of taking such.
Can you speak up a little louder?
Any person. How's that? Okay. Any peace officer may release from custody instead of taking such person before a magistrate. Any person arrested without a warrant whenever B2 says the person arrested was arrested for intoxication only and no further proceedings are desirable. So it deals specifically with intoxication, under the influence of alcohol or drugs.
So then an arrest is performed.
Well, in theory, whenever you take someone into custody, it is an arrest. But under 849B2, you have that person can be released if there's no other attributable charge other than the being under the influence. Because the reason that statute is placed that way is because under simple intoxication, number one, the person is not going to be brought before a magistrate for being under the influence of drugs or alcohol. Well, maybe possibly drugs, depending upon the level, but alcohol especially not. And that's why that section is in there, so that, number one, the jails can release that person and not have overcrowding issues and that type of thing, plus the fact that it is not deemed under the section to be a charge or a statute that's going to be sought with prosecution. Paul, I mean, you read it that way? Is that the way you?
I do, and I would just go one step further, and I'll speak as loud as I can. It's not a crime to be drunk or under the influence. It becomes a crime if you're so drunk or under the influence that you are a danger to yourself or to others. And that's what this is all about.
Or blocking a public roadway.
Certainly there are all sorts of things. There are many penal codes out there to do with various issues. So what happens is someone's out there, they get arrested as they become no longer a danger to themselves or to others. Guess what? They're going to be released because we have a full jail full of other people that are dangerous to this community. And just as we've already indicated, there are these priorities. We have a very, very crowded female section in the jail. Our male population in the jail, because of the realignment, has changed significantly, because now our jail is being used as a prison for felons that are not strikeable, serious or violent felonies, or sex offenders. Now, instead of going to prison, state prison system, and I'm sorry, attorneys, we kick out statutes, things like that. 1178 says they go to jail. So the nature of the people in our jail has changed from people that were committing low-level misdemeanor offenses that are now being sentenced to jail sentence to people that really are committing offenses that we used to send to prison that are now sitting in our jail for longer than a year, longer for sometimes 5-6 years. So progressively, as our jail gets maxed out with people that used to go to prison, it becomes the sheriff is under a legal obligation to find ways to make sure that that jail is not too crowded, or we get sued. He gets ordered to release them, and also at every step in the way there are legal protections involved. So let me turn it over. I know there are questions.
I think I can frame this, from a municipal perspective a little bit that might make sense to you. Last year there were 2,600 647F arrests. That means people being under the influence and unable to care for themselves in a public place. I don't know for sure, Paul. Do you know how many were prosecuted? Okay, my guess is probably a handful at the most.
It is a regular course of our business. It is clearly a low priority offense. I don't have exact numbers. I can certainly provide those to you. What we do, the district attorney's office, you can arrest for probable cause. We have the burden of proving someone guilty beyond a reasonable doubt, 12 jurors.
Okay.
We're not generally picking up we're not prosecuting every person who was arrested for 647F or being so intoxicated they couldn't care for themselves at that time. What we do is look at who they are, what their conduct was, and what their conduct has been. So regular citizen, first-time contact with law enforcement, they get arrested. It's like they've already suffered the consequence of being arrested and thrown into jail. Fair enough, move along. If you're out there all the time, you have repeat conduct, you're in certain areas that we think there is a greater public concern over, the plaza in Arcata, the gazebo area here in the city of Eureka, or the boardwalk, then we're going to look at that a little differently. So we're trying to figure out who you are in the grand scheme of things and not go after everyone just because you happen to have drinking too much.
Yeah, I think the point is the community has to tell us what their pleasure is, and we have to do it with the eye of public safety in mind. For the district attorney to prosecute 2,500 of those 2,600 cases, you would probably need to triple your staff. Yeah, I mean, it takes judges, it takes public defenders. I mean, this is a weighty problem. And it's just, it's more than just simply putting people in jail and then letting them go. So I just want that to be part of your thinking so you can at least express what the community wants. That's all. And I know the public defender wanted to comment on this.
This will be the last comment on this one because we need to move on to other topics if you'd be so kind.
It may be, the confusion might be attributed to my comments a bit. From your point of view as a citizen getting detained by a police officer, there's not a lot of difference between being arrested and detained. The difference is a detention can result in your being released after you come in and the police officer has completed his or her investigation, or you can be released from the jail after they've determined that there's no probable lights flashing and a gun on their hip. There probably is not a lot of difference between the feeling that you have from being detained and the feeling you have by being arrested at the jail and then released. But those are the guidelines. And if I confused anybody, I'm sorry.